So, good afternoon, everyone, and welcome to the monthly Eurosif Sustainable Finance Update. So, as always, thank you for joining our session today. Also, as is typically the case, we have quite a few notable developments in the sphere of sustainable finance to update you on, including some very significant recent regulatory developments. So with that said, we can move on to the next slide and take a quick look at our agenda for this afternoon. So today, we are going to provide you with an overview of the questions sent to the European Commission by the European Supervisory Authorities, or ESAs, concerning key SFDR provisions. Then we will give you a brief update on the joint ESAs draft regulatory technical standards, or RTS, on additional taxonomy-related disclosures under the SFDR. That will then be followed by a quick overview of the ESMA updated guidelines on sustainability-related aspects of the MiFID II suitability requirements. And then finally, we will inform you about the state of play in negotiations on the future EU Green Bonds framework. So throughout the update, we would welcome any questions that you might have. There'll be a short pause after each update to give people the opportunity to ask specific questions. However, if we don't have a chance to come back to you, we also hope to have some time at the end for Q&A. So please don't hesitate also to contact us after this session if your question has been left unanswered. Also, the slides will be made available on our website after the session today, and you will be able to find them through a link in the description below after the live stream is over. Again, the playback of this session will also be available on the Eurosif YouTube channel for you or colleagues to watch back after the session is over. But with that said, I think we can move on to the next slide and dive in to our first agenda item. So on 9th of September, the European Supervisory Authorities sent a series of questions to the European Commission, seeking greater clarity on core provisions of SFDR and how they should be interpreted. Now, as many of you will be aware, this is the third occasion on which the ESAs have sent questions to the Commission in relation to SFDR. There was a set of questions sent by the ESAs in 2021, and then again earlier this year, May 2022, there was another set of questions that the ESAs sent to the Commission concerning SFDR provisions. Now, for a bit of procedural context, while the ESAs have an important role to play in supervising the markets and clarifying how regulation should be applied, their powers are quite clearly prescribed in regulation. And if a question, say, about a piece of legislation requires the interpretation of union law or requires the interpretation of the primary text of a piece of legislation, the ESAs must pass it on to the European Commission. Often when it comes to the ESAs publishing Q&As, which they do frequently in relation to various regulations, their Q&As concern more practical aspects of application. These questions that the ESAs have sent to the Commission really pertain to a question of interpretation. There's something in the primary text which isn't clear, which the European Commission has to provide some more clarity or certainty on. So the level 1 text, as many of us know, of the SFDR contains a number of provisions which require further clarification from the European Commission. Most notably, the ESA's questions focus significantly on the notion of sustainable investment as defined by Article 217 of the SFDR. So the ESA's asked several questions to prompt the European Commission into clarifying what exactly qualifies as a sustainable investment and how financial market participants should calculate their exposure to sustainable investments, say for the purposes of an Article 9 fund, an Article 8 fund that includes sustainable investments, or indeed for their MiFID II requirements. So, for example, to look at one of the questions in particular, the ESAs ask whether the entire value of an equity holding, say in an investee company, should be considered as a sustainable investment in cases where only some of an investee company's activities contribute to an environmental or social objective, and assuming that that company's other activities avoid significant harm. So this approach of taking the entire value of an equity holding is the so-called whole investment approach to qualifying a sustainable investment. The ESAs ask whether that approach should be applied, or whether alternatively, the so-called look-through or revenue-weighted approach should be applied, whereby a financial market participant would calculate their exposure to sustainable investments by determining the revenue derived by an investee company from a sustainable activity that it conducts. So there's that question on sort of the overall approach to calculating exposure to sustainable investments. So we can move on to the next slide, please. In addition, the ESAs ask whether an economic activity must directly contribute to attaining an environmental or social objective in order to be considered sustainable. Alternatively, they ask whether an economic activity carried out by a company more sustainably than its industry peers would be eligible for the purposes of sustainable investment. So while in absolute terms, the activity might not itself be sustainable, but in relative terms, the way in which a company carries out that activity is more sustainable than the way in which that company's industry peers carry out the activity. There's also interesting questions in relation to Article 9.3 or paragraph 3. So as a recap, Article 9, paragraph 3 applies to products with carbon emission reductions as their objective, which make use of EU and other climate benchmarks as part of their strategy. And we can move to the next slide, please. So the ESAs ask that as Article 9 product portfolios must consist almost exclusively of sustainable investments, does Article 9, paragraph 3 imply that all constituents of an EU Paris-aligned benchmark or climate transition benchmark automatically qualify as sustainable investments in accordance with Article 217? So all of these are highly pertinent questions for the European Commission. If we move on to the next step or the next slide, in terms of next steps, the European Commission is now considering its responses to the questions. Now, what I have to make absolutely clear right now is that it's not certain when the European Commission will respond. They recognize that from the perspective of the industry and the market, the subject of the questions is highly sensitive given the state of application of SFDR. So the reality in the market is that up until now, many financial market participants have been left to their own devices when it comes to qualifying sustainable investment. A lot of approaches may be invalidated depending upon how the Commission responds to some of the ESA's questions. Another consideration is that while the Commission does have the power to interpret provisions of the level 1 text of SFDR, it cannot substantively supplement or alter those provisions. That would be, well, there wouldn't be a legal basis for the Commission to do that. That would constitute altering the meaning of provisions of a level 1 text without the involvement of the European Parliament and the Council, which would not legally be viable. So at present, internally in DG FISMA, there is a debate going on as to whether it is best to respond quickly or to wait a number of months before responding to the questions. What I have heard is that they may also be selective in the questions they respond to. So they may not respond directly to all of the questions that the ESAs have posed. But it is quite a sensitive matter, and they're acutely conscious of that at this point. Maybe also just for a bit of insight into the internal process in DG FISMA, I think it's fair to say that the last 2 Q&As that were published by the Commission created quite a bit of confusion in the market. And part of the reason for that was effectively only one unit in the European Commission was involved in the drafting. On this occasion, what differs slightly is that other units are going to be involved and the process will be more coordinated. Just in order to ensure that there isn't any unforeseen consequences to other pieces of sustainable finance legislation arising from some of the clarifications. So for instance, earlier this year in one of the Q&As, the Commission clarified that unless financial market participants have reliable data on the taxonomy alignment of their portfolio, they should indicate zero alignment. The implications of that were not necessarily fully comprehended by the Commission or the unit that actually sort of drafted or made that clarification. So now they'll have to coordinate more closely internally. So that is in relation to the questions sent by the ESAs to the European Commission on SFDR. I mentioned at the outset of this update that procedurally, the ESAs also can issue their own Q&As on more practical aspects of applying SFDR, and they intend to do so at the end of October. But there's a lot of Q&As sort of circulating on SFDR. And so effectively, when the Commission responds to these questions from the ESAs on interpretation of SFDR, that will be the 3rd Commission Q&A. The Q&A issued jointly by the ESAs at the end of October will be the first joint ESAs Q&A on SFDR. And they deal with slightly different issues. One interprets SFDR level 1, the Commission Q&As. The other is more a practical guide to application. So with that, I'll stop here briefly and see if we have received any questions. And if not, we can move to the next slide and proceed with the next update. So in addition to the questions from the ESAs sent to the European Commission on SFDR, on 30th of September, the ESAs also published draft regulatory technical standards, or RTS, for additional taxonomy-related disclosures under SFDR. So the additional taxonomy-related disclosures are meant to ensure that any exposures to taxonomy-compliant nuclear energy and natural gas are apparent to investors and clients. Now, as many of you will remember, particularly if you follow our updates regularly, these additional disclosures in SFDR were necessitated by the inclusion of natural gas and nuclear energy activities in the EU taxonomy earlier this year through the so-called Complementary Delegated Act. So with the draft regulatory technical standards now published, the European Commission must now endorse the RTS and integrate the additional disclosures into the SFDR delegated regulation. Now, the SFDR delegated regulation, just to remind you, sets out the detailed disclosure requirements that FMPs subject to SFDR must satisfy. The SFDR delegated regulation was adopted in April of this year and published in the official journal on the 25th of July. And it effectively provides the product templates that FMPs are going, or well, the disclosure templates rather, that FMPs will have to use as of 1st of January 2023. So these draft RTS from the ESAs suggest additions for taxonomy-related product disclosures in the SFDR delegated regulation. So the Commission, according to standard procedure, has 3 months in which to endorse the draft RTS and integrate them into the SFDR delegated regulation. Now, having said that, the ESAs have really urged the Commission to act promptly given the challenging implementation schedule. So, effectively, you can expect that the Commission will probably act in the next few weeks to sort of swiftly integrate these additional disclosures into the SFDR delegated regulation. Now, it's debatable as to what procedure exactly the Commission is going to follow. I've heard different opinions. From quite a credible source, I've heard that the Commission will not really allow for any public consultation or feedback period when it amends the SFDR delegated regulation. They want to do this quickly and promptly just to give the market time to adjust and implement the new requirements. I know others that claim that legally the Commission will have to allow for some sort of public consultation given that they're amending level 2, but I don't necessarily agree with that view. But that concludes sort of the update on the second agenda item. So I'll just pause here to see whether there are any questions. And if not, we can move on to the next agenda item. I do see we have a question in relation to maybe the last agenda items on the ESA's questions and how to qualify sustainable investments. So someone has asked, how to define sustainable investment in the case of illiquid assets like real estate, and whether the ESA's questions include this aspect. And I mean, the very simple answer is no, this is not actually an aspect that the ESAs have really considered, nor asked the EU Commission about. I mean, it's a valid question, but it might be a little bit too granular at this stage for the ESAs to ask. So I'm afraid, there's no more information than that to offer at this point. But if there's no other questions, we can move on to our next item, which is related to MiFID II requirements. So of course, on the 23rd of September, ESMA published its updated guidelines on sustainability-related aspects of the MiFID II suitability requirements. So the guidelines provide financial institutions and national competent authorities with effectively practical instructions on how clients' sustainability preferences should be gathered during the advisory process, specifically during the suitability assessment, in accordance with MiFID II requirements. So the draft updated guidelines were the subject of a public consultation, which ran from January to April of this year. And the final guidelines are accompanied by a report by ESMA outlining the outcome of the consultation and describing the input that was received from both industry practitioners and consumer associations. And the input received to the consultation was actually highly interesting. And of course, as you would expect, a lot of industry practitioners and even consumer associations pointed to many of the challenges associated with actually applying the MiFID II requirements on gathering client sustainability preferences. So for instance, the fact that a lot of the sort of concepts that clients must articulate their sustainability preferences in are quite abstract. They're derived from pieces of regulation that your average retail investor or consumer is not going to be all that familiar with. And frankly, even a lot of financial advisors are not familiar with. And that makes it difficult. You know, was quite a number of critical comments just about how prescriptive the framework is. Now, encouragingly, ESMA has taken quite a few of these comments on board, and they do acknowledge the challenges that exist in applying MiFID II requirements around sustainability preferences. Now, having said that, ESMA is constrained again by MiFID II provisions, and it must effectively publish guidelines that are consistent with the MiFID II provisions. It can't sort of override or alter the MiFID II provisions. All it can do with these guidelines is give some clarity as to how the industry should go about applying their obligations or honoring their obligations. Nevertheless, you know, ESMA has sort of done what it can. And so in terms of substance, the guidelines do introduce greater flexibility with respect to how financial advisors gather client sustainability preferences, most notably in relation to soliciting the client to specify a percentage of taxonomy alignment or share of sustainable investments when expressing sustainability preferences. So effectively, ESMA now allows through the guidelines for advisors not to seek or solicit clients to provide an exact percentage. Instead, now ranges can be used and minimum proportions, say for taxonomy alignment or sustainable investment, can be set by the client. But there's greater flexibility in that respect now. Another sort of important thing to note with these guidelines is that typically national competent authorities and industry are given 2 months to comply with guidelines. That is once, of course, they are translated into all official languages of the EU. On this occasion, given the challenges applying the framework, ESMA is extraordinarily allowing 6 months to comply. So now in terms of next steps, just to be very clear, these guidelines have been published, but they need to be translated into all official EU languages. It's not clear how long that process will take. It depends very much on available resources, but it can take anywhere between 6 weeks and 4 months. But once the guidelines are translated, then this period of 6 months will be triggered. And 6 months after the guidelines are available in all official EU languages, industry and NCAs are expected to be compliant. So that effectively concludes the update just on the MiFID II suitability requirements and the ESMA guidelines. So with that, I'll just pause here briefly to see, has there been any questions? And if not, we can move on to our next item. So I'll just give 1 or 2 moments, but it doesn't appear we have a question. So I think with that, I can pass you on to my colleague, Federica, for an update on the EU Green Bonds framework, which is in the pipeline. So please, Federica, go ahead.
Thank you, Hugo. So yeah, today we want to briefly update you on the state of the negotiation on the regulation that establishes the EU Green Bond standard. So as many of you may already know, the regulation is aimed at introducing criteria for a voluntary label for green bonds that are marketed in the EU and that want to use the EU Green Bond standards designation. And one of the distinctive traits of the label is the requirement for EU green bonds to allocate the proceeds to taxonomy-aligned projects. So just to briefly recap the situation, the EU Commission published its proposal for a EU regulation on the 6th of July last year. So in mid-April this year, the EU Council agreed its position on the Commission's proposal. And shortly after, in mid-May, the Economic and Monetary Affairs Committee adopted the Parliament position on the regulation. So with those positions being agreed, the negotiation between Commission, Parliament, and Council, the so-called trilogues in the EU jargon, started in July this year. So several technical meetings were held throughout the month of September. And so what are the main points open for discussion at the moment? There are 3 points, which are the scope, the allocation of proceeds and grandfathering, and the civil liability. So I guess that the most relevant issue is the scope. And so with that, we can move to the next slide. So I was saying the scope is perhaps the most relevant issue at the moment because it alters significantly the objective of the entire regulation. In fact, the Parliament proposed to expand the objective of the regulation, which was initially originally conceived to establish criteria for a voluntary label for EU green bonds. And so the proposal is to introduce transparency requirements for all green bonds and sustainability-linked bonds that are marketed in the EU. So it goes beyond a labeling system and proposed a full transparency framework. In particular, the proposal of the Parliament envisaged the disclosure requirements at 2 levels: disclosure requirements for the issuers of EU green bond standards, all EU green bonds marketed in the EU market, and sustainability-linked bonds, and disclosure requirements on the bonds. So we are 2 level. For instance, just to provide you an example, issuers of green bonds and sustainability-linked bonds would be required to disclose on the due diligence policies regarding the PAI on sustainability factors, where, I'm sorry, PAI means principal adverse impact on sustainability factors. Another requirement is that issuer in the scope of the Corporate Sustainability Reporting Directive would be required to get a positive opinion from an auditor about the alignment of their transition plan with climate neutrality by 2050. So this is an information that issuers that are already subject to the CSRD are already required to produce. So the point here is to add this information in the documents attached to green bonds. Another amendment, for instance, say that green bonds that are marketed in the EU will be requested to disclose the taxonomy alignment of the use of proceeds and how the green bonds take into account principal adverse impact on sustainability factors. So we see there are a few requirements both at issuer level and regarding the bond itself. So the main arguments for the Parliament positions are, of course, the need to increase transparency and prevent greenwashing in the EU market of green bonds and sustainability-linked bonds, but also to provide investors with information on the taxonomy alignment of green bonds, also to kind of ensure coherence within the overall sustainable finance regulatory framework. And finally, the Parliament also highlighted the need to ensure comparability between the green bonds and between the sustainability-linked bonds. So at the moment, what we know is that these proposals are not supported by the Council. The Commission seems to understand the reasons of the Parliament, but at this stage, there is no political maneuver to introduce these changes to the initial proposal of the regulation, which are quite substantial because they alter again the objective of the regulation. So the main, let's say, counter arguments of the other co-legislators, as far as we know, are first, the idea that the disclosure requirements duplicate existing disclosure requirements, mainly on the Corporate Sustainability Reporting Directive, as said, and increase the complexity of the framework. The Parliament and the Commission and the Council also highlight that additional disclosure requirements for issuer might discourage the growth of the market of green bonds and sustainability-linked bonds, and perhaps that sustainability-linked bonds are less mature than green bonds at the moment, so probably regulating is not the best option for time being. Another counter argument refers to the verification requirements by ESMA registered reviewers that might create organizational problems and increase costs. So for what concern the allocation of proceeds and grandfathering, very briefly, because I'm conscious of time, and this can be quite technical, but briefly, according to the proposal of the Commission, when the technical screening criteria of the taxonomy are reviewed, the EU green bond standard have green bond labeled have 5 years to adapt. For instance, the proceeds that remain unallocated must be allocated according to the new criteria. So here, the Parliament and the Council proposed some amendments. For instance, the Parliament proposed a 10-year limit in the case of financial claims, and the Council wants to extend the grandfathering period from 5 years, as is in the proposal of the EU Commission, to unlimited. So once the EU green bond has been issued and allocated, there is no further changes are required, even if the technical screening criteria of the taxonomy are reviewed. Regarding the civil liability, in the EU Commission proposal, there is a provision stipulating that issuers that are already required to publish a prospectus, in the prospectus must declare that the green bond is issued in accordance to the EU green bond standard regulation. And the prospectus regulation says that civil liability is attached to information that are incorporated by reference in the prospectus. For instance, issuers can attach by or incorporate by reference the fact sheets of the EU green bond standards, and so that triggers civil liability. So briefly, co-legislators have different views on how to ensure that issuers are liable for potential infringements related to the allocation and taxonomy alignment of the use of proceeds, and also to ensure that investors are able to actually hold issuers accountable for damages resulting from an incorrect prospectus. These are the main points for discussion. So what are the next steps? So the next meetings of the trilogues are scheduled for the 18th of October and the 16th of November. From sources very close to the file, we learned that it is likely that an agreement is reached already in November. However, further round of trilogues in December might also be needed. So in any case, we are expecting an agreement by the end of this year. So with that said, this update on the EU Green Bond Standard is finalized, and I think that I can go back to my colleague Hugo for another question that I see here.
Thanks, Federica, for the very comprehensive update. So now, we have time to address any questions that you may have. I see one question here in relation to the ESMA final guidelines on the sustainability-related aspects of the MiFID II suitability requirements. And it says, what are the specific questions that financial advisors have to ask their clients when gathering their sustainability preferences? And effectively, it's interesting, during the consultation process, a lot of industry practitioners that responded to ESMA actually asked that ESMA should provide sort of a set of questions or guidance as to what precisely financial advisors should say to clients to explain the different sustainability concepts, so things like taxonomy alignment, sustainable investment as defined in Article 217, and principal adverse impact indicators. The ESMA has decided not to be quite so prescriptive, and instead it's stressed that advisors do have a degree of flexibility in how they approach applying or gathering client sustainability preferences is probably the best way to put it. So there isn't a set of specific questions that financial advisors have to ask their clients. They ultimately have to determine themselves what they think the best approach is. Now that may not be ideal because curiously, the MiFID II requirements are, on the one hand, very prescriptive, and on the other hand, they're quite vague, and in terms of practical application, they don't give a lot of clarity as to how financial advisors should go about it. One thing that ESMA stresses is that at this juncture, it's pretty apparent that financial advisors themselves don't really have the requisite level of expertise to satisfy this obligation stemming from MiFID II. And so it's quite important that financial institutions provide adequate training or hire sufficient staff to actually be able to gather client sustainability preferences. Another kind of important sort of comment that was made in ESMA's reports that accompanied the guidelines is that it recognizes the challenges in applying these requirements, and it's going to monitor in the years to come how exactly industry practitioners are applying it. And there's going to be kind of an iterative process and sort of mutual learning between supervisors and industry as to what's the best way to approach gathering client sustainability preferences. But for the present, while things are uncertain, there is flexibility, at least for industry practitioners. So I hope that in some way provides reassurance or answers your questions. But with that, please, anyone else feel free to ask a question. And if not, we may actually have concluded earlier than is typically the case. So we can give you maybe a few minutes of your afternoon back. But again, as always, thank you for joining us this afternoon for our sustainable finance updates. The next update is scheduled for the first Thursday in November, as usual. So we will hopefully see you back here then. Again, I'll just repeat that, of course, a playback of this update will be available on our YouTube channel. and the slides that we used will be available in the description below once the live stream is over and on our website. So with that, we can say good afternoon and thank you and see you in November. So ciao.